Yes, today again I have come to the channel. I thought that I will be discussing on a very important act, which is the Indian Contract Act 1872. It was enacted in the year 1872, and till now it is being carried out. There are not so many amendments. The total number of sections were, there were 266 total number of sections. Out of that, section 1 to 75 deals with the general principles of contract. 76 to 123 deals with the Sale of Goods Act, which is an offshoot of the Indian Contract Act. Then comes your 124 to 238 deals with the special contract, which deals with the contract of indemnity, guarantee, bailment, agency. These are being dealt with. Section 239 to 266. This again, a new act has been enacted repealing these sections, and the new act is being called as the Partnership Act. This Sale of Goods Act and the Partnership Act is basically the offshoot of the Indian Contract Act. The Indian Contract Act mainly concerned with the contracts, general principles of contract and special contract now at present. So the first, let us know what is a contract. That's a very important point, Contract implies that an agreement which can be enforced before the court of law is a contract. That is, that it contains in section 2 subsection H, small h. So, it is an offer plus acceptance is equal to the agreement, and agreement plus enforceability is equal to the contract. But what is enforceability? That's a very important terminology, Enforceability means bringing before the court of law. So an agreement which can be enforced before the court of law is a contract. So all agreements cannot be enforced. And from this equation, what I have just told you now, that offer plus acceptance is equal to the agreement, agreement plus enforceability is equal to the contract. So from that we can say that all contracts are agreement, but all agreements are not contract. An agreement which can be enforced before the court of law is a contract. Say for example, if somebody invites in his or her birthday, and on the birthday that say X has spent a good amount of money, that Y and his family of 3 will come and visit. And on the very day, the 3 person have not turned up. But by that time, he has spent, say, 1500 rupees per dish, say 4500 rupees. Y has not turned up. Can X take a legal action against Y? No, because there is no legal relationship. There is only a social relationship, and the social relationship cannot be enforced. So agreement is nothing but a social relationship, and that is why it cannot be enforced. Very important reference of case is that Balfour versus Balfour. It's a very renowned case which contains that the agreement cannot be enforced unless it is there is a legal relationship. So next important part of contract is that what are the essential elements to make a contract valid in the eye of law? I have given a definition of contract. Now, what are the essential elements to make a valid contract in the eye of law? That deals with section 10, and which should be read with section 2 subsection H. What are the essential elements? The first is that there should be an offerer and there should be an offeree, or offer plus an acceptance. The second one is your consensus addendum, which is a Latin term which implies meeting of mind. There should be a meeting of mind. Third, there should be a free consent. Consent to the parties to the contract should be freely made. That means it is not being made out of coercion, under influence, fraud, misrepresentation, or mistake. Next is the fourth one, the capacity of the person. The person who is entering into a contract should be capable to enter into a contract. And the court has identified that following persons are not capable to enter into a contract. For example, a minor. A minor cannot be a party to a contract, and the minor's contract is void ab initio. Reference of case Mohri Bibi versus Dharmadas Ghosh. Then a person who is insolvent, who cannot, a person who is unsound person, an alien enemy of the country cannot be a party to a contract. They are not capable to be a party to a contract. Then fifth, that there should be a lawful consideration. So now if you say that what is consideration? Very simple. Consideration means sacrifice. Something in return. And no consideration, no contract. When you are entering in a contract, someone has to give and someone has to get that one. Supposing you are willing to buy a flat at rupees say 40 lakhs. The buyer's consideration is 40 lakhs. And the seller consideration is the money that he is getting, that is the 40 lakhs rupees, and the buyer's consideration that he is getting is that the flat. Other way around, you can say that the buyer's consideration is 40 lakhs whereas the seller's consideration is the flat. So consideration is essential, and no consideration, no contract. Section 25 of the Indian Contract Act 1872 deals specifically that contract there should be a lawful consideration. Next, number 6th point, essential element is that there should be a certainty. The terms and conditions of the contract should be certain. If there is no certainty, the contract is not valid. So supposing you are going to buy a land, you should know which land. There are huge land is there. So you have to identify that this is the land I am going to buy. Supposing you are going to buy a flat in a multi-story building. So which flat? That should be identified. That is called the certainty. Supposing you are going to get a job, and for that appointment letter is being issued. So it is the letter, it is said that that your salary will be, monthly salary is rupees, depends upon the performance you make. I can make you sure that you are not getting any salary in any month because your performance is always poor. So you should know what is the salary. You are rendering services. At the end of the month, you should be getting certain consideration. That is whether it is 500 rupees or 5,000 rupees or 50,000 rupees. So the certainty is essential. Next is that 7th point, possibility of performance. That whatever you are entering into a contract, the object of the contract should be capable to be performed. Supposing on a particular land you are going to build a building. So in the next day, the land is being taken over by the government. Because right to property is no longer a fundamental right as per Article 31 of the Indian Constitution. So you cannot execute that contract because it is not possible to perform the contract. The main purpose of the contract has been vitiated. That is a very important thing that one should know. And the last but not least is that it should not be the agreement of the contract should not be specifically declared by the court that it is illegal. Say, for example, an agreement in restraint of marriage, agreement in restraint of profession. So, any contract where there is a restraint of marriage or where there is a restraint of doing profession or business, that contract is totally an invalid contract. This is all for today. Thank you very much.